The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of July 6, 2025, the podcast that downloaded a car. This is your host, Shane Killian. Let's dandify the news of the bogus. So one of the big stories is an update to several cases we've covered where a district court judge got too big for his britches and decided to grant an injunction not just for the parties in the case, not just for his district, but for everyone, everywhere in the country. Supreme Court said, yeah, you can't do that. The particular case they ruled on was the birthright citizenship case, but they didn't rule on the merits of that case, just the injunction. Amy Coney Barrett, writing for the 6-3 majority, ruled, traditionally, courts have issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs in the lawsuit. The injunctions before us today reflect a more recent development. District courts asserting the power to prohibit enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed the equitable authority that Congress has granted to federal courts. She points out, as do the concurrences, that during the Obama and Biden years, Democrats were equally frustrated by universal injunctions against them. In fact, in a 2022 interview, Justice Kagan said,
and it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stop for the years that it takes to go through normal process.
Yet here, all of a sudden, things are reversed. Funny how that works out. Quote, the bottom line, the universal injunction was conspicuously non-existent for most of our nation's history. Its absence from 18th and 19th century equity practice settles the question of judicial authority. That the absence continued into the 20th century renders any claim of historical pedigree still more implausible. Even during the deluge of constitutional litigation that occurred in the wake of Ex parte Young, throughout the Lochner era, and at the dawn of the New Deal, universal injunctions were nowhere to be found. Had federal courts believed themselves to possess the tool, surely they would not have let it lie idle. Yeah, definitely not the New Deal courts. They never saw a power grab they didn't like. But they've got nothing on Justice Jackson, who dissented, proclaiming the full supremacy of unelected district court judges appointed for life, even over that of the president. Barrett let her have it, quote, the principal dissent accuses us of misunderstanding the nature of equity as being frozen in amber at the time of the Judiciary Act. Not so. A modern device need not have an exact historical match, but under Grupo Mexicano, it must have a founding-era antecedent, and neither the universal injunction nor a sufficiently comparable predecessor was available from a court of equity at the time of our country's inception. It falls outside the bounds of a federal court's equitable authority under the Judiciary Act. And she explains why Jackson's opinion isn't just wrong, but dangerous, quote, Justice Jackson, however, chooses a startling line of attack that is tethered neither to these sources nor, frankly, to any doctrine whatsoever, waving away attention to the limits on judicial power as a mind-numbingly technical query. She offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy blush. In her telling, the fundamental role of courts is to order everyone, including the executive, to follow the law. Full stop. Rhetoric aside, Justice Jackson's position is difficult to pin down. As best we can tell, though, her argument is more extreme still, because its logic does not depend on the entry of a universal injunction. Justice Jackson appears to believe that the reasoning behind any court order demands universal adherence, at least where the executive is concerned. In her law-declaring vision of the judicial function, once a single district court deems executive conduct unlawful, the executive must conform to that view, ceasing its enforcement of the law against anyone, anywhere. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. Justice Jackson would do well to heed her own admonition. Everyone, from the president on down, is bound by law. That goes for judges, too. As for Sotomayor's dissent, which Jackson and Kagan joined, she didn't seem to understand that they weren't ruling on birthright citizenship yet and spent most of her time saying dumb things about that instead. In a concurrence, Justice Thomas warned, lower courts should carefully heed this court's guidance and cabin their grants of injunction relief in light of historical equitable limits. If they cannot do so, this court will continue to be duty-bound to intervene. Courts are not there to set policy for the country. They're there to decide cases and controversies. Let's hope this limitation on the power of the judiciary continues, because it's long gotten way out of hand.
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. The Orange Overlord.
Oh, my ear!
Bernie Slanders. Debate Dominator.
My kippa's ruined!
Or Joe Sleepy.
Build me back.
And of course, Mr. Fancy Pants himself.
Forget those losers! You can get the Gold Edition and play as 4 more characters, including me, the Spooky Spaceman, along with Billionaire Brat, Professor Proof, and the easiest way to play, as Jesus himself!
7 complete different worlds, with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral.
And don't forget that Gold Edition, where you can play the ultimate challenge, Devil's Doorstep.
This gory satirical adventure pulls no punches. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
So another example of judicial overreach that someone needs to do something about. You know how I warned that the unconstitutional gag order on Trump would result in courts doing the same thing to regular people like you and me? Well, it happened to a woman in a divorce case. Moondet and Timothy Reeves were divorced, and Moondet had to pay Timothy over $24,000. In January, Timothy moved for her to be found in contempt because she hadn't paid him a dime. The Wisconsin Court of Appeals summarized what happened next, quote, Moondet argued that her failure to pay was not contemptuous because it was not willful, asserting that she did not have the financial means to comply with the order. The court did not find her credible at all. Noting contradictions in her testimony regarding her income, her unreal decision to spend on things like a car payment for her 18-year-old daughter rather than taking care of her obligations, and her admission that she could afford up to $500 per month but had paid nothing, the court concluded that Moondet had willfully and intentionally violated the court orders. It held her in contempt and imposed a penalty of 120 days in jail if Moondet failed to comply with the purge condition of making monthly payments of $900 on her debt to Timothy. But the lower court judge, a Democratic appointee, also found that, quote, there will be no dissemination to a third party about and disparaging remarks about either party in this action, any attorney involved in this action, any court employee, including the prior court judge or myself, in any social media or anything to a third party. If he has so much as a post that he has a screenshot of and he brings it back, that will be considered a violation, even if you continue to pay. The appeals court found 2 problems, quote, Setting aside the issue of whether this broad order could survive scrutiny under the First Amendment, on its face, it would prohibit Moondet from saying anything negative about her ex-husband, any attorney involved in the case, and any court official to any third party, even a friend or therapist, for example. This court concludes that it must be reversed for the simple reason that, as Moondet asserts, it is not arguably related to the conduct for which Moondet was held in contempt. Under our Supreme Court's holding in Larson, a purge condition should be reasonably related to the cause or nature of the contempt. The Circuit Court did not explain how this condition prohibiting disparaging remarks related to Moondet's failure to make court-ordered payments to Timothy, which was the conduct that led to its finding of contempt. In defending the condition on appeal, Timothy only vaguely argues that Moondet refusing to comply with orders and cooperate with the process is the very root of the problem, such that adding a purge condition to restrict the disparaging remarks and to protect the court and the people involved is reasonably related to the cause of contempt. This court does not see the connection and concludes that there is insufficient nexus between the purge condition and the contemptuous conduct. Good thing the appeals court struck it down, but if it can happen in a simple divorce case, it's probably happening a lot, which means this might be something else the Supreme Court is going to have to step in on.
If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv.
And another update, this time for the Fourth Circuit's ruling that Cox is liable for its users who pirate. As we've covered over the years, the RIAA has been attacking Cox Communications for doing nothing about pirating users, which means they didn't kick them off the internet just because some half-assed bot run by a record label claimed they were pirating. Unbelievably, a Virginia jury found that Cox should have to pay $1 billion to 53 record labels, right on the heels of settling with BMG for $25 million. The basis of it was, basically, Cox should have had a crystal ball to know who was going to continue to infringe, and past performance is a guarantee of future results. Quote, sufficient evidence supported a finding that Cox materially contributed to its subscribers' direct infringement of plaintiffs' copyrights. As the court explained, Cox's internet service was indispensable to each instance of peer-to-peer infringement on its network. Well, so was the electricity going to their homes. Do they get to sue the power companies next? Quote, it is true that mere failure to take affirmative steps to prevent infringement does not establish contributory liability in the absence of other evidence of intent. But supplying a product with knowledge that the recipient will use it to infringe copyrights is exactly the sort of culpable conduct sufficient for contributory infringement. And Cox should be an unpaid law enforcement arm, and not even at the behest of the government, but at Sony and other labels. Quote, Sony presented extensive evidence about Cox's increasingly liberal policies and procedures for responding to reported infringement on its network, which Sony characterized as ensuring that infringement would recur. And the jury reasonably could have interpreted internal Cox emails and chats as displaying contempt for laws intended to curb online infringement. Yeah, how dare you display contempt for our wonderful unconstitutional fascist laws? So Cox petitioned the Supreme Court, quote, generally, a defendant cannot be held liable as a willful violator of the law and subject to increased penalties without proof that it knew or recklessly disregarded a high risk that its own conduct was illegal. In conflict with the Eighth Circuit, the Fourth Circuit upheld an instruction allowing the jury to find willfulness if Cox knew its subscribers' conduct was illegal, without proof Cox knew its own conduct in not terminating them was illegal. ISPs are much like telephone companies. They have limited ability to police how customers use the communications infrastructure they provide. ISPs cannot block access to specific sites, prevent download of particular content, or monitor what their users are doing online. And if they did, the privacy protests would be deafening. They have no way of verifying whether a bot-generated notice is accurate, and no one can reliably identify the actual individual who used a particular internet connection for an illegal download. Nevertheless, the music industry asserted that once an ISP receives allegation that a subscriber's connection has been used to infringe, it is obligated to enforce the law by terminating the subscriber's internet connection. The Fourth Circuit's approach is also wrong. As that court itself has acknowledged, contributory liability is a species of aiding and abetting liability. Twitter, like Grokster, made clear that a defendant cannot be secondarily liable unless it engaged in conscious, voluntary, and culpable participation in another's wrongdoing. In fact, the court concluded that merely continuing to provide infrastructure to someone engaged in wrongdoing is not an affirmative act demonstrating the requisite culpable participation. It is mere inaction that does not establish culpability absent breach of an independent duty to act. The Fourth Circuit's rule disrupts the doctrinal consistency concerning secondary liability on the Internet. If the Fourth Circuit had followed Twitter's teaching, it would have concluded that a provider of online services cannot be secondarily liable merely because it provides a general use product or service, despite knowing that a subscriber has a history of misusing that product or service. There is no reason to think that Congress intended such a topsy-turvy regime, where direct infringers face enhanced willfulness damages only where they have culpable knowledge about their own conduct, but where secondary infringers face enhanced damages regardless of their good faith and reasonable beliefs. A few weeks ago, the U.S. Solicitor General published an amicus brief urging SCOTUS to grant cert, arguing that ISPs should not be considered liable for pirating subscribers, warning that the precedent may lead to innocent subscribers losing their internet access, and urging them to deny a petition from the music companies wanting to expand the verdict. So in its most recent order list, Cox v. Sony showed up on the list of cases where certiorari was granted. At the same time, it denied the petition from Sony and the other music labels. Both are good signs. Although they didn't provide any reasoning, it seems reasonable for them to think that Cox has a good point, but the record labels don't, and both are in agreement with the Solicitor General's opinion. Cox said in a statement, "We are pleased the Supreme Court has decided to address these significant copyright issues that could jeopardize internet access for all Americans and fundamentally change how internet service providers manage their networks. Today's development supports our goal of protecting consumers, preserving open internet access, and ensuring that broadband remains a reliable resource for the communities we serve. We look forward to presenting our arguments to the court." We're looking forward to it as well. Hopefully this will be another reversal of a long-standing tyranny against the people.
I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv.
And now it's time to characterize this week's biggest Bogon emitter. Okay, so you remember that highly edited CBS interview of Kamala Harris where they desperately tried to make her appear more mentally coherent than she really is? Let's review. Here's what actually aired on 60 Minutes.
But it seems that Prime Minister Netanyahu is not listening.
We're not going to stop pursuing what is necessary for the United States to be clear about where we stand on the need for this war to end.
And here's how her answer really went.
Well, Bill, the work that we have done has resulted in a number of movements in that region by Israel that were very much prompted by or a result of many things, including our advocacy for what needs to happen in the region. And we're not going to stop doing that.
So, yeah, subtle as a brick and twice as painful. Deceptive news coverage is one thing, but it's another thing entirely when it's done to mislead people about candidates in an election. And what's interesting is, in a system that was prosecuting people over memes, somehow the news media gets away with repeatedly violating the actual agreement broadcasters have to follow in exchange for their oligopoly over the public airwaves. Back in May, Trump rejected a $15 million settlement offer from CBS News. Wait, you think you're just gonna buy off Trump for just $15 million? Who do you think you're dealing with, Joe Biden? Seriously, you need Elon money to pull that off. So now, the total settlement seems to be over twice as much, but it's not just about the money. It's about how to hold the news media more accountable. Now, whenever CBS and any other Paramount Global property interviews a presidential candidate, they are required to make the unedited transcript available. In the Harris interview, we only got the unedited version after the FCC got involved. Meanwhile, the FCC is also fielding complaints about Disney's ABC News and how they moderated the TV debate between Biden and Trump, as well as Comcast's NBC allowing Harris to appear on SNL before the election. Although the settlement doesn't include an apology, this is at least a good start for CBS. Imagine if they all had to make the true facts of their stories available to the public. Or, even better, ditch the whole idea of government-supported broadcasting monopolies to begin with. So all of that makes CBS this week's biggest Bogon emitter.
Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-aged children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins.
And now let's flabbergastrooccasional and mentify this week's
Idiot Extraordinaire!
You know Elie Mystal, that commentator that looks like he hasn't cut his hair or changed his hairstyle since the late 1970s? He's famous for his epic meltdowns in reaction to anyone who shows the slightest bit of rationality. But he's really outdone himself this time. I'm assuming you listened to the first segment. If you didn't, you might want to give it a listen because that's the Supreme Court decision he's talking about. So what's so bad about not giving each and every little pissant district judge the power to overrule the president for the whole of the United States? You have to hear it to believe it. Good thing this is an audio podcast.
Imagine Donald Trump wants to do something illegal to you, Elie Velshi. Imagine that he wants to murder you.
Of course that's what it is. With SEAL Team 6, I suppose.
So you, Elie Velshi, you go to court. You go to court in the Southern District of New York and you say, like, I don't think this murder thing is constitutional. It's clearly illegal. It's clearly constitutional. Donald Trump and Pam Bondi and Stephen Miller shouldn't be able to have a plan to murder me. And the court says, you're right, Elie Velshi. There's no way Donald Trump is allowed to murder you. We're going to have an injunction. And then Pat Kiernan shows up and he's like, what about me? And the court's, well, I can't help you because Elie Velshi is the one who sued.
Listen, idiot. If Kiernan goes to court, the courts can apply it to him too, because he's now petitioned and become a party to the case. Do you not understand how any of this works? And by the way, what if someone goes to another district, one where the other party is in power, and gets a nationwide injunction going against you? 2 words, moron. Forum shopping.
Donald Trump starts murdering people. That is the upshot of yesterday's decision.
Remember what I came up with for Dan O'Dowd? Applies to Mystal too. Stultus ipse loquitur. I don't need to explain this. The idiocy is so obvious and so extreme that it speaks for itself.
And basically what the Supreme Court has said is that, well, you said something about Jimmy, but you didn't say anything about Consuela, so we're going to deport Consuela while the Supreme Court figures it out.
Wait, this wasn't even about deportations. Did you forget what the case even was? Stultus ipse loquitur. The idiocy speaks for itself. Oh well, keeps the segment short at least. So all of that makes Elie Mystal this week's
Idiot Extraordinaire.
Well, that wraps up this Take That Horse and Put It Back Under That Idiot edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord, Patreon, or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Jonathan Zittrain. The flourishing of information technology gives amateurs and home recording artists powerful tools to build and share interesting, transformative, and socially valuable art drawn from pieces of popular culture. There's no place to plug such an important cultural sea change into the current legal regime. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.